Hello, and welcome to our webinar, Why Women Need an Estate Plan. My name is Tammy Weber, and I'm a certified elder law attorney here at Marshall, Parker & Weber. Let me give you a little backdrop and an introduction as to why we're doing this webinar today. Women are a very powerful economic force, and they face certain important challenges. As of 2018, there are 12.3 million women-owned businesses in the United States. Compare that back to 1972 when there were only 402,000 women-owned businesses. Women control 39%, or $11.2 trillion of all investable assets in the United States as the decision makers, not just the influencers. And women-owned business generated $1.8 trillion in sales in 2018. This is just 4.3% of the total private sector revenue. More than half of women do not have financial advisors. And estate planning is one of the very complex areas of wealth management. And it's also, unfortunately, one of the most overlooked. A well-crafted estate plan can help you arrange the distribution of your assets after you pass on, help you carry out your philanthropic wishes, perhaps make the settlement of your estate less difficult or costly for your loved ones, and potentially reduce estate taxes, eliminate probate costs, or reduce them and add liquidity to your estate to cover end-of-life costs that may have been incurred or any applicable estate taxes. Women tend to live longer than men, so they need to plan for this longer life. On average, women's life expectancy is 5 years longer than men. Their money has to last longer. And when you live a longer life, we know from the medical statistics that there could be higher health costs for chronic health conditions at the end of your life. Another thing that impacts women is that 2 out of every 3, or 66%, of family caregivers are female. So they may be caring for people like their parents or children or adult children with disabilities during their earning years. So that impacts their ability to save and the amount of money that they can amass. According to the AARP statistics, the average caregiver is a 49-year-old woman who works at least part-time and has been taking care of an aging parent for several years. So the first step is let's do some planning for incapacity. Hope that it doesn't happen, but if it did, do you have the documents in place that would allow your agents or your loved ones to act for you? So there are 2 kinds of powers of attorney. A power of attorney is a legal document that can be used during your lifetime. So when you pass away, the power ends. A financial power of attorney can be 2 types. One is springing and one is immediately effective. So what do we mean by springing? That means you've chosen your agent, so the person or persons that's going to act for you, and maybe your backup people, and you've signed those papers and they're legally effective. But you've decided, even though I sort of trust these people, I may be too young, or I just want a second set of eyes. So you've said in your financial power of attorney, this cannot be used by my agent until there's a letter attached from my physician saying that you're unable to handle your finances. So that means it springs into action or can be used when there's a physician letter attached. The downside of this is people could be in and out of competence or having capacity during their lifetime. So each time that something happens, you would have to go back and forth to your doctor to get a letter that says, oh, okay, now you do have competence and you can handle your own affairs. The second type of financial power of attorney is immediately effective, which means once you sign the documents, appropriate witnesses, and your agent signs an acknowledgement that they know that they've been chosen to act on your behalf, then that power of attorney can be used. This is the predominant amount of financial powers of attorney we do. The second kind of power of attorney covers your healthcare decision making. By definition, this is springing, meaning it can't be used by your agent unless a physician says you're unable for some reason to handle your healthcare decisions. A healthcare power of attorney would cover three things. One is the Health Insurance Protection and Accountability Act back from the late 90s. We all know those as HIPAA releases. That's typically what, when you go to the doctor, they ask you to sign. Who can we tell what's going on with your health? So that would be the first thing under the healthcare power of attorney. The second would be treatment decisions. So if you are in a car accident or you've fallen at your local grocery store, hit your head, you're unconscious, you're not going to die, you just can't make a treatment decision. Your agent would make those decisions for you. The third part would be just related to end of life decisions. So some people call this a living will or an advance directive. And this comes into play in the situation where a physician or physicians, depending upon your preference, says you are at the end of your life and you're permanently unconscious. So this would be where you would say what your philosophy is. For many people, it's, I don't really want treatment that's artificially going to be prolonging the process of my dying, but I want to be kept comfortable. So it gives more flexibility to the agent or agents that you've chosen to make decisions for you in your stead. If you are awake and at the end of your life, you can make your own treatment decisions. One thing you need to think about when you're planning for your incapacity in your power of attorney documents is who's going to be the best decision maker. You don't want to say, oh, my oldest child, or whatever. We see lots of preferences. You want to think about who's going to make the best decisions. And especially when it comes to healthcare, the more conversations that you have during your lifetime when you're well, the better the results you're going to get if you're unable to make them for yourself. Another type of planning for incapacity during your lifetime for some people is setting up a revocable living trust. So again, another legal document that would spring into action perhaps if for some reason you lose the ability during your lifetime to handle your investments, or you're just really tired of it and you decide to use a professional advisor. This document would say how things are handled. So if you choose to fund your trust, and by that we mean transferring your savings account, for example, instead of having it into your individual name, have it in the name of the trust, you would be the trustee during your lifetime until you decide to have somebody else be in charge. But you would have the legal framework ready to go. And typically when people pass away, these revocable trusts turn into irrevocable trusts, and they list where the money or the property were to go. Very similar to your will, which is part of planning for death. What's in your will? What's in your trust? So most people have heard of a will or a last will and testament. And that covers things that are in your name alone when you die. So for example, if you have a checking account and it's in your name alone, it would go under your will. If you have a checking account and it's jointly owned with a spouse, a significant other, or another person, when you die, by operation of law, the other owner, joint owner or owners, automatically owns that money. It doesn't go through your will. Similarly, if you own real estate jointly as joint tenants with right of survivorship or as tenants by the entireties, which is the nomenclature for people who are married, when you die, your spouse or the other joint owner automatically owns it. So in your will, in addition to saying where things are going to go, so if you have children or a spouse or a significant other, or if you have philanthropic wishes, you lay those out in your will. You choose somebody to handle and follow the will. That's typically called the executor or the executrix if it's a female. Um, and that person's charge is to wrap up your estate, get things where they need to go, pay the appropriate tax, if any, that's owed to Pennsylvania, and wrap it up and file the inheritance tax return with the Department of Revenue. In your will, you consider whether you want to set up any what are called testamentary trusts. So, for example, you may have heirs that aren't great with money, or you think, oh, they're really influenced by their spouse or their significant other. You can set things up that say, here's a trustee that's going to be in charge of the money or property. And you can set it up that the income could pay out over a period of years so that the beneficiary doesn't just blow it all once they get the check from your estate. Another type of planning for death or trust. So we've talked just a tad about revocable trust, which means you're still the trustee and you can change it at any time. There are also irrevocable trusts. So those are often done for various purposes, and I will note, as with everything when we talk about it on a webinar, we don't believe anything is one size fits all planning. Everyone has particular facts and circumstances in their life, both in terms of their beneficiaries and the assets that they hold. So an irrevocable trust can also be done for incapacity, which I'll talk about in a bit, but it's a way to put a framework in place that you know, and you can't change it, when you're gone, here's where things are going to go. So an irrevocable trust or a revocable trust can be set up that you get the income, for example. It depends on the situation. Another thing that's very important for planning for death, and what I see is really somewhat overlooked or not explained fully, are the lovely taxes. I can tell you nobody likes taxes. When you pass away in Pennsylvania, there is an inheritance tax. It's currently 0% for anything going to a spouse or a charity, and it's 4.5%, and this is based on the date of death value of the asset, for things going to children or grandchildren or parents. And it's important to think about this when you're writing your will and working with your certified elder law attorney. Do you want those taxes that have to be paid out of your estate? Or do you want the people that are receiving your money to pay the inheritance tax out of their own pocket? There are pluses and minuses to each of these options and should really be discussed in full. There are also income taxes. So when, say, I passed away and in my name when I died was my house, and I bought my house for $50,000. That's my basis, my tax basis in my house. But when I pass away, it's worth $100,000 on my date of death. So there's been $50,000 of appreciation during my lifetime. If I leave that to my child is paying inheritance tax on the date of death value of $100,000. In other words, my child gets a step up in tax basis. So my child is paying 4.5% inheritance tax on that $100,000 or $4,500. But my child also doesn't have to worry about the accumulated growth and the capital gains taxes that could be at odds. Another tax issue, an income tax issue, is new with respect to the Secure Act, which was passed at the end of last year, but is effective for anybody who passes away on or after January 1st of 2020, and how your beneficiaries can receive your retirement accounts. So it's something that, of course, you want to talk through. And there are other articles on our website, paelderlaw.com, to which you can refer if you want to hear about the Secure Act and planning. Another issue or discussion with estate planning is planning for remarriage. Now, we know the divorce rate is around 50% or a little bit higher. And people also lose their spouses. So one of the ways to talk about if you've lost your spouse or you're divorced and you want to be clear that the assets that you either brought to the marriage or maybe bringing to the marriage should stay yours if there's a death, then you have to talk about it. A way to do that is by a prenuptial, so you do it before you get married, or a post-nuptial, you do an agreement after you get married. And in that agreement, you can talk about, so say for example, I brought a house to the marriage and I kept it in my name alone. As long as I don't add my spouse's name to it, if we were to get divorced, that house wouldn't be subject to equitable distribution. However, currently, the growth in the value of the house during our marriage would be subject to equitable distribution if there isn't a prenup or a postnup. You also want to think about, well, what if I lose my spouse and they remarry? One of the ways people do this is they say, yeah, I hear it all the time. Well, if he or she died, I would want them to be happy. They want me to be happy. But what the spouse that passes away probably didn't want is for the hard-earned assets together to go to the next spouse or significant other. So a way to do that is to set up an irrevocable trust. So let's continue to use the house as an example. If during the marriage there's a house, it's jointly owned, you put it into an irrevocable trust, meaning instead of the name of the spouses, it's owned by the trustee. And the trust would say, upon the death of both of those spouses, here's what happens to the house. It's sold, it goes to their children, whatever the plan is. You can also deal with, in those irrevocable trusts, a spendthrift trust. So what if one of your beneficiaries is either a big spender or has some personal issues or is highly influenced by the person with whom they live? You can set it up in such a way that it's protected, your asset. Or perhaps your beneficiaries are minors. They're under the age of 18. If your child has passed away, and that's why money is going to a minor grandchild, for example, you may not want the biological parent of that minor grandchild to be in charge of the money. So you can set up a trust, pick a trustee that may be one of your other children or a friend or a financial institution and have them be in charge of the money instead of your daughter-in-law or son-in-law. And again, some people love their daughters and sons-in-law. Some still love them, but don't want to give them in charge of any money. So various considerations for all. The next thing, which is very big for women, is to plan for long-term care. Statistics nationally are if people go to a nursing home at age 65, there's probably a 40% chance that you're going to spend some kind of long-term care and need it. And people that do go to a nursing facility are there in an average of 3 years. Women, longer. Men, shorter. So plan ahead. Take the time. It doesn't cost any money to look into the various kinds of long-term care insurance. So you have to physically qualify, and typically the younger you start this process and choose, the less expensive it is and the more likely you're going to get approved. There are various kinds of long-term care insurance, and I urge everybody that to look into it. And if you don't have a trusted provider, please feel free to email us at webmail, WEBMAIL, at PAElderlaw.com, and we can give you some names of people who give it. But long-term care insurance is better than it used to be when it first came out, in that if you pay premiums in the past, in the 90s or so, and you didn't need it, you died, the money died with you, just sort of like your homeowner's insurance. If you have no loss, you didn't get anything out of it. There are different policies now. For example, there's what's called a hybrid policy, where you can purchase a couple $100,000 of long-term care insurance, which would include a nursing home, a personal care home, or some people call them assisted living, or home care. And if you have $200,000 of coverage and you don't use any of it during your lifetime, it goes to your beneficiaries as a life insurance policy at 0% Pennsylvania inheritance tax. So it's a good option. Other kinds of insurance are looking at what you need for your health care and the like. Some people, for planning for long-term care, purchase some kinds of annuities, or they also said an irrevocable trust that we've already talked about on one hand, but it has a different application when it comes for planning for long-term care. So let me just review it a little bit. Think about it for long-term care as this. You go down to the bank and you say, I want a safe deposit box. There are some assets and things that I just need to lock up. And if there's a fire or theft, I want to protect them as much as I can from life circumstances. So you fill out an application, the banker gives you a key, and you put into that box those things, those valuables that you don't want to lose. So how about we think of the safe deposit box as an irrevocable trust? You put in the irrevocable trust or fund it, which is changing the name on either the real estate or the investment from your name to the name of the trustee. So in the irrevocable trust, you place things that you don't want to lose from the cost of your care. And they're held, the keeper of the key, if you will, is your trustee. It's not your trustee's personal asset, and so it's not a risk of your trustee's personal circumstances. Or you can have a financial institution with trust powers as your trustee, and they're holding the key. If you've transferred things into an irrevocable trust and you've lived through, without needing to go to a nursing home, 5 years, Then if you apply for Medicaid or medical assistance, which is state and federal money to pay for your care in a nursing home or at home under the waiver program, they don't count what's in that irrevocable trust. So another way of saying it is if you've gotten through the 5-year look back, everything in your irrevocable trust, if properly drafted, is considered an unavailable asset for Medicaid purposes. And again, we have other webinars on that topic if you'd like to hear about it in more depth on our YouTube channel at paelderlaw.com. The next thing for planning for women is charitable giving. So there could be lifetime gifts. And so let me just circle back. We talked about inheritance tax. And so that's a death tax in Pennsylvania. There's also potential for a federal estate tax. Currently, that's $11.58 million per person that you can, during your lifetime, exclude from a very high 40% federal estate tax. In addition to that lifetime exclusion, you can give away $15,000 per person per calendar year and not eat into your lifetime exclusion. However, if you're giving away $15,000 and applying for Medicaid, which is a separate rule that we just talked about, because that gift is over $500 in a calendar month, it's going to create a period of eligibility for you. If you want to hear more about that or read more, there is an article about misconception 3 on planning for long-term care, paying for long-term care on our website. So you might want to make lifetime gifts. If you have a lot of money, you're philanthropically inclined, you may want to do that through a bequest in a will. So what that means is I give $25,000 to XYZ Charitable Foundation. You could do the same thing if you had set up an irrevocable trust. There's another plan for you can set up charitable trusts. Those are important for some people who may need a tax credit or a write-off during a year and not really need access to all that principal. So they would give away a certain amount, retain the right to receive the income during lifetime, but when they die, part of it is going to go to the charity of their choice, and that gives them a credit for taxes during their lifetime. There's also charitable annuities, CRATs and CRUTs. You might have heard of both of those, different for different people. What you need to know, though, is a very good financial advisor working with a certified elder law attorney and perhaps your tax professional is a good team to come up with the best plan for your current value, your current estate. Look ahead and see what your projected value is at the time of death and how much you need to live on whether you're retired or not, based on your assets. We can certainly help with that, and we want to talk about it with you and update it pretty much every year or so. And the final thing I want to talk about today is the importance of beneficiary designations. So when you die, some things go because you've listed a beneficiary. An example would be life insurance. You've listed who receives it, so it's a contract. Doesn't matter what your will says. If you have an annuity, you have a beneficiary. A retirement account as well. Very important on retirement accounts, because if it's a retirement account that's a traditional IRA, for example, and the income tax has been deferred, if you don't have a person listed upon your death, not only is the date of death value of that retirement account subject to inheritance tax, it's also all the deferred income tax would have to be paid if you do not have a person listed as the beneficiary. When it comes to planning for divorce, or if a divorce happens, the way Pennsylvania treats a divorce, if you didn't come in to update your will, it's just treated as if your husband or your wife has predeceased you, and your contingent beneficiaries in your will would receive your assets upon your death. However, with certain retirement accounts, if you haven't gone and changed the beneficiary designation from your ex-spouse to your alternate heirs, it doesn't matter that you've been divorced. Federal law will override, and you may be making a death gift to your ex-spouse. And most people I know really don't like to do that. So thank you for joining us today. We look forward to meeting with you in the future. Take care. Be well, everyone.